Good morning, everybody. Very shortly, my colleague Kate Newman will be talking to you about the UK's competition law landscape and emerging trends and so on, and I'm sure you'll find this talk extremely interesting. As ever with these, the seminar is going to be recorded, so you can watch it again if you're that enthused, and the slides and everything else will be sent round afterwards. Please do let us have questions during the webinar. Please put them in the Q&A box rather than the chat, and we'll deal with questions at the end. Kate is going to speak for 35 minutes or so, and then we'll deal with questions. You can be down as a participant either with your name or anonymously. Excuse me. Either is fine. If you put your name, I won't say your name when reading out a question at the end. If you're anonymous, that's fine, but if we don't happen to get to any question you put, then we'll find it rather difficult to track you down and answer the question separately afterwards. So I would urge you to put your name if you feel happy to do so. And I think we're probably doing, either at the end or being sent around afterwards, there'll be a survey as to future topics and stuff like that. So anything you get from us, please do respond, because these talks, we want them to be relevant to you and your organisations and so on. So the more feedback you can give us and the more you can tell us what you want, the more we can do that. So without further ado, I'm going to hand over to Kate to tell us everything competition law.
Thank you very much, Simon, and good morning. Welcome to this webinar. So, as Simon said, I'm going to be talking today about competition law landscape in the UK and emerging trends. And on the agenda, you'll see the topics I am going to be covering. So, after a brief recap on the UK's competition rules, which are mainly there to provide you with some context before we move on, I'm going to be covering the big story in UK competition law, which is the Digital Markets Competition and Consumer Act 2024, which I'm going to refer to as DMCC. I'm then going to cover and talk about the Competition and Market Authority's strategic priorities, give a snapshot of enforcement activities that we've seen by the CMA, and I'm going to finish by just talking briefly about some trends in UK merger control. So first of all, to set the scene and provide some context to what I'm going to be covering in terms of the trends. So competition rules are intended to safeguard free and fair competition between undertakings, which for these purposes you should understand really as being any form of entity which conducts an economic activity, so very broad in its scope. And the UK's competition rules regulate the conduct of undertakings in the markets in which they operate by prohibiting, in essence, three things. First of all, agreements and practices which have as their object or effect the prevention, restriction, or distortion of competition in the UK. That's known as the Chapter 1 prohibition, and I will be touching upon that a little bit later. Secondly, there's a set of rules which prohibit the abuse of a dominant position if that abuse may affect trade in the UK or part of it, referred to as the Chapter 2 prohibition. And thirdly, the rules also prohibit mergers which result or may be expected to result in a substantial lessening of competition within any market in the UK, or again, substantial part of it, and that's under the Enterprise Act 2002. So the purpose really of these rules, as I said, is to safeguard free and fair competition so that you and I as consumers benefit from lower prices, better choice of products, better quality of goods or services, and increased innovation. And to motivate businesses to comply with their rules, there are a series of consequences which may flow for businesses which do not comply with their obligations, which can include a whole range of things. Just a couple to call out here really before I move on to the main part of the presentation, which is the possibility of an investigation, which can often be fairly lengthy. In the UK, most CMA investigations last at least 18 months, sometimes more than a couple of years. And if there is a finding at the end of an investigation, a finding of a breach, then a company can face a fine of up to 10% of group worldwide turnover, as well as facing damage to reputation, negative publicity, as well as the headache and hidden costs of dealing with a CMA investigation. There are other consequences which I've mentioned on the slide. I'm not going to talk about those in further detail because they are not directly relevant to the presentation today, but they are there for relevance. And if you're interested in looking into those, you now know where to look. So I'm going to turn to the big news story of the year, which is the Digital Markets Competition and Consumer Act 2024. So this has been, it was in bill format for quite some time and received royal assent on the 23rd of May this year in the wash-up and is expected to come into force in the autumn. We are all watching and waiting to see when that will be. We are working on the basis that it will be at some point in October when the new legislation will take effect. And it really has sort of three main areas of reform. So first of all, it introduces into UK law a new regime for the regulation of digital markets, which will be administered by the Digital Markets Unit, which is a part of the CMA, and it's based up in Manchester. And this new regime will have particular significance for firms who are designated by the CMA as having strategic market status, or SMS, and these firms will be subject to much greater oversight and specific conduct rules about how they behave in their markets. The second main part of the legislation relates to a significant overhaul and reboot of the UK's competition law regime, the most significant reboot there has been since 2013, so very important. And the changes will see a significant strengthening of the CMA's investigation and enforcement powers, as well as some changes to the UK's merger control regime. The third element, which I'm not going to talk about today, but will be covered, I believe, in the next In-House in Focus webinar, relates to a sweeping change to the UK's consumer law regime. Again, a very important aspect, and this will be dealt with in a future session. I'm going to talk about, therefore, the digital markets regime and then to talk about the reboot of the competition law regime more generally. So the digital markets regime. Now, this has been described by the CMA as a watershed moment for the way in which the CMA regulates digital markets, and will really, once it becomes fully fledged and fully active, will place the CMA very much at the heart of the UK's digital economy. So the regime will enable the CMA to regulate in a proactive ex ante way the largest and most powerful digital firms with the aim of encouraging innovation and effective competition in digital markets. You might have heard about a similar regime in the European Union called the Digital Markets Act, and both have share very similar ground, I suppose, in terms of the policy objective. There are many similarities between the UK's new digital regime and the EU's Digital Market Act, but there are some key differences. Primarily, that the CMA's new regime will allow it to create and put into place more bespoke interventions and conduct rules for the largest firms who are designated as having strategic market status. In contrast, the EU regime has taken an approach of, I suppose, prescribing and codifying certain conduct which designated firms should not engage in. So it's a slightly different approach, but very much with the same aim in mind. So the starting point for this new regime is really this concept of SMS. And the CMA will be able to designate a firm as having strategic market status if it carries out at least one digital activity linked to the UK, it has substantial and entrenched market power and strategic significance in respect of that digital activity, and has global turnover of more than £25 billion globally, or UK turnover of more than £1 billion. I mean, just to unpack some of those elements in a little bit more detail, I suppose one thing to note is that the designation is in relation to a digital activity, and this means the provision of a service by means of the internet, whether for consideration or not. So that will cover, for example, social media platforms as well as e-commerce platforms, or the provision of one or more pieces of digital content, again, whether for consideration or otherwise. And therefore, this would extend to things such as software, music, computer games as well as apps. The definition is intentionally flexible, and we expect to sort of see how that will shake out in practice as the designation process gets underway. Designations can only be made after a proper evidence-based investigation with a time limit of 9 months, and designations will stay in place for 5 years and will then be subject to review. So it's not intended that there will be kind of a crystallization of SMS status and never to be reviewed ever again. It is intended that the designation will be relatively dynamic, as you would expect in markets and digital space, which will also be dynamic in its nature. So the regime will have 3 pillars. So first of all, for firms that are designated as having SMS status, the CMA will be able to impose conduct requirements that will set out how firms are expected to behave in relation to the relevant digital activity. And the conduct requirements will be driven by objectives of fair dealing, open choices, trust and transparency. The, I suppose, underlying idea or concept being that firms having this position in their market in respect of these digital activities, and with digital activity being so prevalent in the lives of all of us as consumers, that consumers should be able to deal with these firms in a way which are governed by these principles. So this is the kind of proactive form of regulation. But the CMA will also retain, as part of the second pillar, the ability to intervene in respect of any conduct that it identifies as causing an adverse effect on competition. So this is the idea, similar to its current functions, that if there's an issue, then the CMA will be able to investigate and act if it concludes there is an issue. And thirdly, there are going to be a new set of merger reporting requirements, so that SMS firms will have to report mergers to the CMA with a value of at least £25 million and a UK connection. So this is also intended really to kind of bring to the fore and ensure that the CMA is aware of merger activity where, for example, a firm with SMS designation might be buying up a much smaller competitor or possibly a more innovative competitor, with the fear that that acquisition could remove dynamic competition from the marketplace. As you might expect, with such a sort of seismic change to the UK's regulatory regime in this respect, there's going to be an extended period of consultation. The CMA has acknowledged quite openly that it has still to develop its understanding of how SMS firms operate in relation to their various digital activities, both technically in terms of the actual operation of these activities and in terms of their business models. And the CMA has said that in many cases, it will be for the SMS firms to decide on the actions that they take to comply with any requirements that the CMA may place on them. So we can therefore expect the Digital Markets Unit to administer the regime in a way which will have a kind of a constant process of engagement with stakeholders, not just including the major tech players who are likely to be designated as having this status, but equally challenger firms and users who can give their perspective from the other end of the telescope as to how they find the experience of interacting with these firms. So the CMA has started its process of consultation. The first piece of draft guidance was published last month. It's a very substantial piece of guidance. It's about 188 pages in length, and the CMA will be wanting to listen to a range of views. At a conference a couple of months ago, when I was speaking to someone from the DMU, they made the point that it's quite easy for them to talk to the big tech companies. There is that sort of open communication already, but they're very keen to hear from sort of challenger firms and users. So this is an opportunity out there for other firms in the market to really say their piece about how this regime may impact upon them. So with that in mind, the CMA did publish back in January with the enactment of the bill on the horizon an overview of how it expects to approach the DMCC. So first of all, it has said it expects the number of firms to be designated with SMS status to be very limited. Well, which I don't think really is a surprise when you look at the criteria for the designation. And there will be a period of time before we see those designations come through. The first designations are expected in July 2025, so a year away before we actually start seeing some decisions being made. But as I said, do expect a lot of activity around the consultation of how this regime will work in practice before the actual formal process of investigation and designation gets underway. The CMA has also said that it expects this regime to be a complement to its other tools. So it's not a case that this regime will supplant other forms of regulation or competition enforcement. That's not intended to be the case. It is seen as being an adjacency, albeit a very important one, to the CMA's existing toolbox. And thirdly, there is, as I said, this real desire for there to be active and meaningful engagement with stakeholders as the regime comes on foot, and indeed as it actually moves into the live practice stage. Digital markets move at an unbelievably fast pace, and the CMA will be keen to stay abreast of developments. So as I said, the initial focus will be on SMS investigation and designation, so watch this space in about a year's time. But what does this mean for the world at large, other than those firms who are likely to be designated as having strategic market status? Well, I think it's probably fair to say it's probably too soon to say with certainty how this will shake out. But I would say that the conduct rules, which will be, as I said, bespoke to individual firms in relation to relevant digital activities, may well have an impact on how a whole range of businesses interact with these tech giants. And therefore, there is an opportunity now to contribute to the conversation around how the regime will operate in practice on the process of designation, as well as the rules themselves, and also potentially in the future, an example of how competition law can be used as a sword to challenge conduct where that conduct has an adverse effect on competition. So it is a piece of legislation of very broad application, and one that we'll be keeping a close eye on for many years to come. Okay, so I'm now going to talk about the sort of second bucket of changes in the DMCC. So these relate to the existing competition law regime. As you might expect, a lot of the publicity and debate around the DMCC has been around digital markets, and that's not surprising. But it is really important to remember that the other set of changes relating to a reboot of the UK's competition law regime is the most significant set of changes since 2013, and is something which all businesses in all areas of the economy should be aware of. And I'm going to take you through the key changes. So first of all, the DMCC extends the territorial application of the Chapter 1 prohibition, which I mentioned at the beginning of the presentation, which is the prohibition against anti-competitive agreements and understandings. And when it takes effect, the Act will extend the prohibition to agreements which are implemented outside the UK, but which have an effect within the UK. So particularly relevant to those businesses where they may have an HQ overseas in the US, in the European Union, somewhere perhaps in Asia, where agreements are kind of take effect elsewhere, but there is an effect on business within the UK. I mean, this was intended really to kind of close what's perceived as a loophole, and really to bring the UK's regime into line with the way in which many other sort of mature competition law jurisdictions operate around the world. I would say, just briefly as an aside, that the second prohibition, which I mentioned, the Chapter 2 prohibition, which prohibits an abuse of a dominant position, there is no change there to the territorial scope of that prohibition. And infringing businesses must still have a dominant position within the UK. So that does not change. The second area I wanted to touch upon were these enhanced powers of investigation for the CMA. So these changes have come about really to address concerns on the part of the CMA that the toolkit, as it was not adequate for effectively investigating and prosecuting anti-competitive conduct in the UK, and thereby impeding the ability of the CMA to really deliver the goals of competition law. So these are really intended to really boost the CMA's investigative powers. So first of all, there will be a new duty to preserve evidence where a person knows or suspects a CMA investigation is being or carried out or is likely to be carried out. This is quite a significant extension from the current position whereby there is only a legal duty to preserve evidence, which is the subject of a information notice or a particular investigative measure. It remains to be seen how this will actually work in practice. I mean, many clients and many firms who are under investigation do choose to kind of take an expansive approach to evidence and its preservation. But what's important here is that what was best practice will now become a legal duty. And it may be very easy in some cases to know when an investigation is on foot. For example, if a business receives a case initiation letter, that's obviously a clear marker that there is an investigation underway, but this requirement around or is likely to be carried out is a little bit more amorphous, so that could present some practical challenges. The CMA will also have wider powers to interview individuals. So at the moment, the CMA can only interview an individual if that individual has a connection with the business under investigation. That is going to be broadened out to any individual could be required to attend an interview in connection with an investigation. So really quite an expansive extension there of the CMA's powers. And the CMA will also have the power to carry out remote interviews, really to reflect a change in working practices. But again, it could present some challenges if attending an interview with people in different locations, because the dynamic of an interview on Teams would be very different from a dynamic of an interview in person in the same room, where it might be easy to catch someone's eye at a particular point during the questions. There'll also be enhanced powers to enter premises and obtain information which is stored electronically, which is accessible from the premises, regardless of where the documents are located. So this is aimed to capture a scenario where, for example, documents are stored outside of the UK, perhaps on servers in the same jurisdiction as overseas HQ, or cloud-based storage scenarios. And there's also an extension to the CMA's powers to seize and sift evidence. Now, at the moment, the CMA can only seize and sift evidence when it is conducting a dawn raid under warrant at business premises. This will change and will give the CMA the ability to use its seize and sift powers when carrying out a dawn raid at domestic premises under a warrant. So this is when the CMA could enter, say, the home of an MD or a CEO, simply take away, seize part, evidence which they think may be relevant to their investigation, and then take it away and sift through it at a later date. And again, this may well have implications for how businesses sort of organise themselves in terms of dawn raid protocols and procedures, and will certainly, I think, need to be something to be considered going forward. Thirdly, enhanced powers of enforcement. So these apply across all areas of the CMA's work, and again are really intended to strengthen the CMA's abilities to act in this space and really to create a deterrent effect for companies who are subject to CMA investigation. So at present, for businesses who fail to comply with an information requirement or an information request could face a fixed penalty of up to £30,000 and or a daily penalty of up to £15,000. And the CMA's view was that this is really inadequate and falls some way short of the powers at the disposal of other competition authorities. So what the legislation does is really up the ante quite significantly. So businesses in the future who fail to comply with information requests or who provide false and misleading information or who falsify, destroy or conceal evidence could face a fixed penalty of up to 1% of global turnover or a daily rate of up to 5% of daily global turnover. So we're moving from a kind of codified sort of tariff-like concept for penalties to a turnover-related threshold, which would significantly I suppose, increase a company's exposure if they fail to comply with a procedural requirement. Similarly, for companies who fail to comply with the CMA's directions or orders or undertakings or commitments given to the CMA, again, you could see fines of up to 5% of annual global turnover, or a daily rate of up to 5% of daily global turnover. So, as I say, I think this really raises the stakes in terms of compliance with the kind of procedural aspects of dealing with the CMA, and also I think will significantly increase the compliance burden on businesses who are subject to a CMA investigation, and I think will really mean that companies have to think very carefully about how they comply to make sure that they don't inadvertently fall foul and could face a sort of significant penalty. And finally, on this part dealing with the DMCC, just a brief word about mergers. I mean, the good news is that the UK's merger control regime remains voluntary, so there's no obligation to tell the CMA about a qualifying merger, and also the regime remains non-suspensory. So even a qualifying merger, in that case, the merger parties can decide to complete without waiting for any form of clearance or comfort from the CMA. There are some changes, though, to the thresholds, which are quite important. So first of all, thinking about when a merger would qualify for review, the turnover threshold for the CMA to have jurisdiction over a merger. This relates to the UK turnover generated by a target. This is raised from £70 million to £100 million. This is to take account of inflation. There'll also be a new safe harbour for smaller deals, so where a merger only involves undertakings with a UK turnover of less than £10 million, those mergers will be exempt, and this is really intended to assist SMEs and micro businesses who are engaging in M&A activity. The most significant change will be a new acquirer-focused threshold, which will allow the CMA to intervene in deals where one party has a share of supply of goods or services in the UK of at least 33% and a UK turnover of more than £350 million. And the other party simply has to have a UK nexus. So this is intended really to expand quite significantly the CMA's jurisdiction to intervene in acquisitions involving targets with little or no UK turnover. This is really intended to catch what's been termed killer acquisitions, so where small innovative companies who really don't have very much turnover or not much of a market presence are acquired by a much bigger player, and the fear there that dynamic competition is lost. But equally, this new expanded test could well capture vertical mergers, so mergers between businesses at different levels of the supply chain, which otherwise would not have been caught, as well as so-called conglomerate mergers, where there is no overlap between the parties' activities, but actually the merger could involve parties who are active in adjacent spaces. I'm going to say a couple more words towards the end about UK merger control. So I'll just mention briefly now that as well as changes to the turnover thresholds, there are some welcome changes around how the CMA's procedures work, which are intended to achieve greater efficiency and flexibility for merger parties. So that's also some good news. So having given you a whistle-stop tour of the DMCC, I just wanted to cover in the next 5 minutes or thereabouts an overview of the CMA's strategic objectives and trends. So first of all, just a snapshot of what's been going on at the CMA. Aside from all the talk around digital markets, the CMA has had a substantial volume of work in 2024 with 24 open investigations on its books across a range of industry sectors. Interestingly, that range only has a few digital market-related investigations, but the other areas cover all sectors of the economy. So transport, communications, the motor industry, construction, media, pharmaceuticals, financial services, and retails, to name but a few. As I said, there are 4 ongoing cases concerning the large digital companies. That's reduced since last year. And there are 3 ongoing cases relating to competition issues in labour markets, which is a new area of focus for the CMA. And I'm going to talk about that in just a moment. Aside the enforcement activities, the CMA has also been pretty busy in its markets work. So this is an area of work undertaken by the CMA, which enables the CMA to assess whether a market is working well for consumers. So it doesn't require the CMA really to decide whether the conduct of a specific firm has breached the competition rules. It's much more holistic review of whether a sector is working well, or whether there are structural or kind of deep-seated issues which require adjustment or mitigation, really to ensure that consumers are getting the benefit of competition. So we've seen a number of, we've got 4 significant market investigations on the stocks. You've probably heard about the veterinary services for household pets market investigation that's received a lot of publicity, but also house building, cloud services and mobile browsers and cloud gaming, as well as 2 market studies. So a kind of smaller version of a market investigation, more of a preparatory, I suppose, investigation into how a market is working on road fuel and infant formula and follow-on formula. But alongside, there's also been an initial review of AI foundation models, again, very much linking to the CMA's digital agenda. And in terms of what the CMA wants to do in 2024 and 2025, there's very much a consumer focus around acting in areas of essential spending where people are under particular financial pressure, such as travel, caring for ourselves and others, and accommodation. And also a clear steer that the CMA is still committed to deterring anti-competitive behaviour across a range of different areas, including labour markets, which I'll come on to in a moment, as well as this desire and aim to continue to act in existing and emerging markets, which includes sustainable products and services, and its green agreements guidance, which I will turn to shortly as well. But first of all, I wanted just to mention the focus on labour markets. So this has been a debate that's been rolling around for a while in competition law, the competition law community, about the role of competition law, I suppose, in labour markets. I think previously there was a view that labour markets was very much the domain of employment law, but it has become very clear in recent years that certain practices in labour markets fall fairly and squarely within the scope of competition, and that competition law does have a role in regulating labour markets. So this is thinking about companies competing to win and attract talent. So companies who may not actually compete downstream in terms of their goods or services may nonetheless be competitors upstream when competing to win talent, particularly if a talent pool in a particular area is limited. So the CMA has said it wants to tackle issues in this area, and it's concerned with 3 main types of anti-competitive behaviour. So no poaching agreements between employees, wage fixing agreements between employees, and instances where employers share commercially sensitive information around how they hire, retain and pay staff. There are 3 ongoing investigations. 2 concern TV producers and broadcasters concerning the employment of staff and the purchase of services from freelance providers. 1 relates to sport, 1 relates to non-sport, and a 3rd investigation relating to ingredients for fragrances, which concerns alleged anti-competitive practices relating to reciprocal arrangements for the hiring and recruitment of staff. It's a very active area for the CMA. We understand from the CMA that there have been a number of leniency applications made in relation to concerns about conduct in this area. And I think we will see more investigations and more enforcement activity coming along. So for in-house counsel, understanding how your organisation hires and retains, attracts staff and hiring practices, and whether there are any issues there, I think would be time well worth spent. I wanted briefly to mention green agreements guidance. So for those of you who joined my Competition Law Essentials webinar about a year ago, I did say this was coming. This is just intended to give a brief update. So the Green Agreements Guidance is intended to help businesses navigate initiatives whereby they collaborate with their peers across industries to try and find solutions, either to tackle the climate crisis or to enter into agreements which will help deliver sustainability goals. So the guidance was published in October last year and explains the circumstances in which collaboration between competitors to protect or enhance environmental sustainability may or may not be a competition law problem. It's an excellent piece of guidance. I would commend it to anybody who is thinking about their ESG agenda. It's very well structured. It's very clear in what types of collaborations will not cause a problem at all, and gives some really useful guidance as to the type of collaborations which may be more problematic. And importantly, it also sets out the CMA's open door policy. So the CMA has encouraged companies to come forward and discuss with them initiatives to help identify whether there may be concerns. And the CMA is publishing guidance. There are two examples which I've mentioned on the slide. And I think as time goes on, we will see more guidance being published, which will help businesses navigate through this area. So again, watch this space. Just in a final couple of moments, I'm just going to say a little bit about UK merger control. I'm not going to talk through this slide because I have mentioned the key elements already. So I'm just going to turn to a few stats just to bring some of this to life. So I looked at the CMA's published statistics for FY 23-24 just to give you a flavour of what the CMA is doing in this space. So in that financial year, the CMA made 54 decisions at phase 1, of which 33% of those cases were cleared unconditionally, and of which there was an intervention by the CMA in 54% of cases, meaning either the CMA decided to refer a deal to a phase 2 inquiry, or the merger parties gave commitments to address the CMA's concerns. There were also abandonments of deals in 4% of those cases. So it seems clear from those stats that the CMA has been very busy in this space. I think the stats also show that the phase 1 part of the CMA's process does operate very much as a kind of initial filter, and where there is complexity or the CMA identifies kind of prima facie concerns, that does tip the balance towards intervention, because the risk of intervention or the rate of intervention is shown to be high. In more than half the cases the CMA looks at phase 1, there is intervention in some way, shape or form. On the other hand, I think the CMA would say that this just shows that the regime is working well, and actually it's the right kind of cases are coming to them for consideration, and where cases do present at that sort of phase 1 stage an indication of concerns, and they are referred for a detailed phase 2 investigation. The other point to note, I think, about merger control, and I think this is my final slide, is that the CMA continues to be very hot on procedural infringements. An example here, so Copart Hills Motors, this was a transaction that was cleared this time last year, but notwithstanding that it was cleared, nonetheless, Copart then went on to face 2 fines after clearance in relation to a failure to comply with a formal request for information during phase 2, so a £25,000 fine. Going forward, that fine would be potentially much larger because it would be a turnover-based fine, not a kind of tariff-based fine, and then also face a very substantial penalty of 2.5 million for failing to comply with an order that had been imposed on it. So the CMA is active in this space, not just in terms of the kind of consideration of whether deals give rise to issues, but also they're very alive to procedural matters and are very sort of vigilant as to when companies don't comply with procedural requirements. And as we see the DMCC come online later this year, I expect the CMA to continue to be very busy in this space. So a few key takeaways just to wrap up. So CMA will be gearing up for the DMCC, and there is a continued focus on protecting consumers. So for all businesses, I would encourage you to think about what this means for you and whether there are any areas of challenge or indeed any areas of opportunity. Thinking about labour markets, there is more enforcement action, I think, coming along. So this is an area where time will be well worth spent whether identifying if there are any areas of risk in your business, and if so, to mitigate and take steps to address that. The guidance on sustainability agreements and the CMA's open door policy, I think, is a very welcome change in the last year and may well present opportunities. So I would encourage everyone who is thinking about their ESG agenda to consider whether that guidance will help. And finally, for any businesses planning transactional activity, the CMA is very busy in this area. It's very active, and therefore transaction planning will be key. And that's everything I had to say.
Fantastic.
I think I'm just within time.
Brilliant. Thank you very much, Kate. Well, we've got a few questions, I'm pleased to say, so we'll rattle through these in order if we may. So someone has asked, in a post-Brexit world, how heavily will the UK's competition law landscape now start to differ from the EU's? Where are those differences going to be?
Well, there is the possibility of divergence in the post-Brexit world. The UK courts are no longer required to have regard to EU judgments around this. So there may be some divergence when a market, say in the UK, operates differently from, say, a European market. However, I do think there is a desire on the part of the CMA and other regulators to align, given that business is conducted on an international stage these days, and significant divergence I don't think would serve anybody very well. So I think there is a desire to continue to work together and align where it's possible.
Fantastic, thank you. The next question we have is what competition controls are there on being a dominant customer within a market, assuming that's the ultimate customer and doesn't then sell on or package goods?
So I think dominance is dealt with under Chapter 2 of the prohibition. So any player who is has a dominant position is under a special responsibility not to behave in a way which harms competition, either by excluding competitors or exploiting customers. I could talk for hours about dominance, so I will just keep it very brief. But it's that part of the regime which would be applicable to any player who is dominant in their particular market.
Yeah, thank you. And someone has asked, with this new power to interview unconnected persons, does that extend to a company's customers? Might they be?
Could do, yeah. I mean, yes, in theory. I think it remains to be seen how that power will be exercised in practice, but yes, it could extend to a customer or a supplier, even a competitor, possibly.
Okay, well, which leads on to the next question, and this may be one of those ones which, again, on which you could speak for a long time. Is there a legal definition of competitor? And this particular questioner has said, we convene industry groups, so we are trying to identify where those meetings are high risk. How do you identify competitors?
Well, there isn't a kind of a concrete definition set in stone, deliberately so that there is some flexibility. I mean, when thinking about competing, it's those who you actually sort of see in your marketplace, and you as a business self-evidently think of as being the people from whom you're trying to grapple with when winning custom. But equally, competition also extends to potential competitors, which is a lot more challenging to think about in terms of who might be coming into your space to compete. So you have to think about both, and it's a dynamic. It has to be a dynamic evaluation because markets change, and who's your competitor today may not be a competitor next year.
Yeah. Okay. Well, to that question, that might be one to speak to Kate separately about.
Yes, please do.
The next question, talking about the emerging trend, the labour markets and no poaching agreements, and do you think that will affect a standard non-solicitation clause in commercial agreements where there's been no poaching of employees for 6 months or whatever it might be? Is that likely to be problematic?
Yeah, look, I think it probably would fall within the scope of what the CMA might be interested in. I think it will come down to specifics, and the devil will be in the detail. I mean, if there's a particular reason or a very good commercial reason why a non-solicitation clause is required, then it may be acceptable. But I think you would be able to have to point to some evidence as to why that's needed. I think kind of blanket non-solicitation clauses might be more problematic. I think it's one to have a look at in the context of the specific arrangement. Okay. So yes, I would say worth a look.
Thank you. A couple more. Next one, do you have any commentary on the scope for public bodies acting within their, public remit, but in doing so provide a service that other people charge for. Would the public body be subject to investigation from the CMA?
So this comes back to the kind of concept of what is an undertaking, which can be any body that performs an economic activity. I mean, there's been a whole line of cases back in the day about public bodies undertaking a public service. But for example, just to give you a sort of flavour, so education, for example, it was felt for a long time that education was outside the scope of competition law, but actually it is now very much seen as an economic activity, educational services, and falls fairly squarely within competition law. So I think you have to be very careful if you're seeking just to say, well, we're just a public body undertaking a public service. So yeah, interesting one.
Okay, and the final question we have, what are the pros and cons of a mandatory notification rule for mergers, even though that wasn't included in this latest tranche of legislation?
Well, okay, I would say a pro for a mandatory notification system is that you have certainty as to when you have to go and approach a regulator, and then you can then build that into your deal timetable, and avoids a situation that you have in the UK whereby the CMA can call in transactions for review after completion, which can lead to fairly significant levels of risk for businesses. So there is certainty. On the one hand, that has to be balanced against more time, cost, delay, etc. But you've seen some jurisdictions like Germany, for example, where for sort of straightforward mergers which have to be notified, phase one, the phase one process is pretty quick. So it's there's been a debate about whether or not the UK should move to a mandatory regime. Interestingly, Australia, which for a very long time had a voluntary regime, has just moved to a mandatory regime. So I don't think this debate is off the table. Watch this space in the years to come.
Fantastic. Well, that's it for all the questions. To all the people attending this talk, thank you very much. I hope you found it as interesting as I did. I hope you found it useful as well. Obviously, I'm sure Kate will be happy to be contacted by any of you to chat through these issues. When the slides come around, do please link in with either or both of us and let us have any feedback you can on this session and what you want for any future session. But thank you very much for your time.
Thank you.
Morning.